Counsel? Is this yours? Okay. Oh, okay. Good afternoon, ladies and gentlemen. Please, the court, counsel. As you were told, this is a murder case, and over the years, I have handled quite a few murder cases. They all have a lot of things in common. There's a lot of pain, there's a lot of sadness, there's loss, there's the human things, and we all feel it. But this is one that's got something that no other murder case has, and they talked about it right at the very end. It's the only time I can think of where everyone will agree that you did not intend to harm, much less kill anybody, yet you can still be taken to court and put on trial for murder and for assault in the first degree. And that's where we are. And I am going to use the word accident, and accident's not just limited to sometime when you drop something out of your hand. Accidents happen because people make mistakes and people are negligent. And this accident, like many others, happened because of negligence. But not just his negligence. And yeah, he's got some part in it. He's got a role in this. He's got accountability in this case. I'm not here to tell you that he has none. What I'm here to tell you is he doesn't have the kind of accountability that they claim he has. In order to get this beyond just a case of negligence with a tragic and horrible result, they've got to do a couple things that are different, and that's a substitute for the cases where you intend to kill somebody, because we know that's not here. What they've got to prove here are some specific things. And it can be summed up, not completely, but extreme indifference to the value of human life that he was aware of and consciously disregarded a substantial and unjustifiable risk that injury or death would occur. And it must be a gross deviation from the standard of care that a reasonable person would observe, as opposed to just not exercising the standard of care a reasonable person would observe, which is just negligence and not any crime at all. This is a traffic case, and we're all familiar with the rules of the road, and I think the court will help some because we'll get some instruction about what some of these things mean. We know and we'll admit that when you're driving down the road and the white sign with the black lettering says 25, you're not supposed to go more than 25 miles an hour. Now, one thing I didn't ask anybody during the jury selection process was whether anybody had ever gone faster than 25 miles an hour when it said not to, and we'd still be here talking to everybody if we did. But that's the kind of thing that could prove negligence. Disregarding a risk is negligent. But they've got to get the negligent plus, and what they've got to do, I think, is to do it one of two ways. I was going to play a video clip. Go ahead. Can we go ahead and play that? It's the same video clip they play, but I want to watch it again in this perspective. That doesn't look like.
I think it's on your end.
The defense is coming out with a strong opening. They're working on technical difficulties.
Let's go ahead, just to not knock me off too much, and play that again. Again, and before you play it, what we're looking for is impairment here. And I want you to just watch this, and I'm going to get as much body cam in front of you from this trial as I can, because this is all fresh after the scene, and you've got to make a judgment about impairment. Can we do it? This happens every time when I try to do something.
Okay, so I'm driving. I just come in and it just. I know this over here they play golf over here. Okay. But you see I come and you stop. I can't stop too. That was the standard. There's a sheep stop. Okay. That's okay. I'm driving.
Okay. And I think what Dr. Davis is going to tell you is that with the blood alcohol reading that he thinks, we would expect Mr. Pozo Ilias to have certain characteristics going on then that you don't see here, about how he's able to handle himself, how he's able to speak. He's hard to understand anyway because of the accent, but not because of impairment. He's able to stand, he's able to walk. You'll see a lot of this, and you'll see it during the actual test that they're talking about too. And I want you to pay very close attention to him during those tests, because you're going to see, I think, what I see, and that this is a man who, for whatever those numbers say, is not impaired at this time. I think you're going to hear that after this happened, and this is just minutes after, this is, I think, the first officer on the scene, or one of the first there. This little area out in the sun, and the temperature is 94, 95 degrees this particular afternoon. There's virtually no wind. As you can see, there's not a cloud or rain cloud in the sky. It's hot, and they stay out there, sometimes standing, sometimes sitting, for about an hour and a half in the sun. He gets nothing to drink, no bathroom breaks either. Another half hour to get downtown, then they start taking blood out of him. The other thing they got to show you for the gross deviation, the conscious disregard, is a rule of the road that was meant for pedestrians. Could you show us the next one?
Okay, so
All right. That, and you'll see a bunch of pictures of that. I've been calling it the golf cart emoji. It's there. There was another one, I think, earlier on in the trip. There might have been one for pedestrians, but what you'll find out, and we have to be careful with this, because this is part of the rules of the road. And when they were telling you in voir dire about the judge gives you the law is that is not a stop sign or a yield sign. It's an alert sign only, all right? Alert that golf carts might be in the area. And again, we're talking about negligence, and who is supposed to know golf carts would be in the area? Him. But it's not a yield sign. It's not a stop sign. It does not tell you an absolute. Then they go to the next signal. Would you go to the next picture? That is right before. And you say, well, that's the same picture just further away. It is. In driving up that road, this is the first point, the earliest point where you can see that there's a white line across it. Now you'll note when you're here going across in your golf cart, you come across the white line, white striped lines, and it's pretty clear where you are supposed to cross. But that's to let the golf carts know where they're supposed to cross. Drivers can't see that as obvious. Now they're going to talk about speed and intoxication, and I am not here to tell you that he wasn't speeding. Okay, I'm not here to tell you he wasn't speeding. I'm not here to tell you that he wasn't drinking. These are questions of degree. When I was asking about science and so forth in the voir dire, there are going to be questions we have about some of these computations that they have made to show that he was going quite that fast. I think 40 miles an hour is a little bit more accurate. It's still faster than 25, and I know, I get it, but it's not quite what they said. You're not supposed to have, and he didn't say, what he said was, they asked him, what did you have to drink? He said, a small bottle of Hennessy. Nobody asked him when or in what circumstances, what else he was doing. So I'm not here to tell you that he hadn't been drinking anything, but I am here to tell you that he wasn't impaired. And the negligence that you've seen in this case, or that you will see in this case, is not the kind of thing that leads to charges of murder or assault. And it's just that their solution to this, to try to convict him of murder and assault in the first degree, is so unreasonable under these circumstances that we have no choice but to come and put this in your hands and let you all decide this. And I'm going to ask you at the end of the case to find him not guilty of murder and not guilty of assault in the first degree. I don't know what else may be there. I don't know what position I'll take on it. But as far as those two, I'm going to be asking you to find him not guilty of both those charges. Thank you.